Good morning, Judge Daffue.
Good morning, Chief Justice and all other commissioners.
Did I pronounce your surname correctly?
100%. I know there are differences, but I prefer it the way you do. Thank you.
Thank you very much. How are you this morning?
I'm feeling fine, thank you, Chief Justice.
CJ? There's no one there.
Thank you, thank you. Secretariat, the commissioners who are on the virtual platform.
We're here, Chief Justice.
Or you can hear?
Yes, thank you, Chief Justice.
Oh, but
Chief Justice is gone.
Oh, hello, Sabon. Thank you. Okay, all right. Okay, we have started. Judge Daffue, I am able to respond on behalf of all the commissioners that we are all fine.
Thank you.
Yes. Thank you very much for availing yourself to be considered for appointment to the Supreme Court of Appeal. We have adopted selection criteria and guidelines which assist us as commissioners in asking candidates questions that will help us to make up our minds about the suitability of each candidate. All of us here want to make sure that you are treated with respect and courtesy. And when we ask you questions, don't ever think that there is anybody who wants to humiliate you or anything like that.
Thank you.
We, nevertheless, will be robust where we need to be robust, but throughout our questioning, we will bear in mind that you need to be treated with respect and with courtesy. So I will ask you questions. After I'm done, then the Deputy President of the Supreme Court of Appeal will ask you questions, and thereafter the Minister and other commissioners. Okay. MPA was from Buckinghamshire. Yes. And you were appointed as a judge in 2011, is that correct? 2012?
Yeah, from the start, from the 1st of January 2012.
Yes. So that means you have been a judge now for just over 10 years, 11 years?
No, I will be, at the end of the year will be 12 years.
At the end of the year, you'll be 12 years. Okay, all right. And during that time, you have sat in criminal matters, civil matters, motion court, civil appeals, criminal appeals. Is that correct?
That is correct.
And you have also had an opportunity of acting in the Supreme Court of Appeal. Is that correct?
That is correct, yes.
Did you have one acting stint there, or have you had more than one?
No, I had 2 acting stints of 3 months each, or the 2 terms, which is then 6 months in total.
Yes. And how did you find it?
I find it unbelievable. It is something that I dreamt about, and I must say that the kind of work and the submissions by council were obviously of a bit higher standard than you'll get in the High Court, and that was refreshing to be involved in some intricate matters, and I find it very, very satisfying.
Are there branches of law that you found yourself involved in at the Supreme Court of Appeal that you had never been involved in, either in practice or in the High Court?
I must say that in the one case of the unlawful competition, I haven't been doing that as a judge, but I've done it as an advocate. So, save for that, the other matters I've been doing I was accustomed to that.
Yes.
And I must, for example, I also did a income tax matter. Whilst in the High Court, I think I only did 3 or so. But again, as attorney and advocate, I did a lot of tax work those days.
Yes. So if you were appointed to the Supreme Court of Appeal, what value do you think you would bring to that court?
Chief Justice, I think I've got a lot of overall experience. The last couple of years but let me start at the beginning. As an attorney, for example, I was a conveyancer as well. So I did a lot of conveyancing, all property law issues, administration of estates, insolvent and deceased estates, trust law, divorce matters, and then obviously the criminal and matters that I dealt with both as attorney and advocate. And then as my program, or as my I evolved in my business as an advocate, I did a lot more administrative work and also commercial work, trust law, company law, that kind of thing was that I dealt with, and I'm sure that I can make a huge contribution to the SCA pertaining to all commercial matters, and also administrative law. So I'm satisfied that I will be able to bring that experience. But I think more important is that my work ethic, my diligence, the way that I deal with my matters and finish them in time and quickly, and make sure that I understand the matters that are placed before me and do proper research and then write well-researched judgments, that will bring a lot to the SCA with great respect.
Now, you do know, of course, that the Supreme Court of Appeal also has constitutional jurisdiction, is that right?
That is correct, yes.
Yes. Have you dealt with matters, whether in the High Court or Supreme Court of Appeal, where you had to declare legislation to be constitutionally invalid?
No, I haven't done that. It was not necessary up until now, although I have dealt with many matters where I had to deal with constitutional issues and balancing the various bills, various rights in terms of the bill of, in terms of the Constitution. So, but I haven't declared any legislation invalid at this stage.
Mm. Are you familiar with what the approach is if you are called upon as a judge to declare legislation inconsistent with the Constitution and invalid? Are you familiar with how you go about that?
Chief Justice, yes, there should be, in the High Court definitely, in terms of Rule 16, there should be proper notice to all the relevant stakeholders, so that everybody that has an issue, the various departments and stakeholders that they have the right to respond, and also for amici curiae that want to deal with issues for them to also apply to make presentations to the court. So one cannot do that without everybody taking part in the process.
Yeah, no, I understand, but I was more interested not at the procedural aspects that precede the actual hearing. I was more interested at the level where now you are writing a judgment. Now you have had argument. You have to decide whether the legislation is inconsistent with the Constitution and therefore invalid, and consider remedies or not. Are you familiar with how to go about that?
Yeah, the judgment is made, but it is normally suspended to allow for rectification by Parliament. Obviously, if it is the judgment is made, it's got still have to be. Should be taken to the Constitutional Court for a final. That is now as a High Court judge for final adjudication or final determination of the constitutionality.
Yes, but before you come to the point where you talk about the remedy, when you are just talking about, you want to answer the question, is this statutory provision or is this legislation inconsistent with the Constitution and therefore invalid? Are you familiar with where you start and where you go up to where you end?
Chief Justice, I must say that I am not that familiar, but the point would be is that the legislation should always be tested against the Constitution, and if the legislation is not cannot be accepted as constitutionally valid, then you can make the order of constitutional invalidity.
Yes. In terms of the judgments that you have written and that have been reported, are you able to take 1 minute or so to share with the commissioners which one you regard as the most important and what legal principle makes it important that it enunciated?
Are you referring to only one matter?
Yeah, just discuss one, and just 1 minute, maybe I'll give you 2 minutes.
Yeah.
Say this is the case, this is the most important one as far as I'm concerned,
Yeah.
and this is the legal principle
Yeah.
that makes it important.
Well, I think if I can refer to two more recent ones, it's the first one is the Weststation versus Castro matter, where it went to the SCA in Centric Insurance Company, where I dealt with and interpreted an insurance contract and the exclusion clause. And the matter went on appeal, and Kashali JA in a unanimous judgment dealt with my views on that. That may have been the end of the story, but then what happened is with COVID and many insurers trying to get away from liability, indemnity liability, didn't want to accept the claims, and then in the matter of guard risk insurance, the SCA was again asked to deal with the matter, and the reliance was placed specific on Centric. And as I said, Centric referred to my judgment. The other one was that may be relevant is the Lawrence matter, where I just said that the shortlisting proceedings were unlawful and unconstitutional, where the appellant, the SCA, also confirmed the attitude that I took there. bearing in mind how Section 174 of the Constitution should be interpreted. And I think those two, in short, would be the last one. For example, is the Misimango case where the Constitutional Court accepted the way that in which I applied Section 342A of the Criminal Procedure Act, insofar as I closed the case of the accused persons without them testifying because of delay, and the courts was satisfied that the proper procedure was taken and the exceptional circumstances existed for the order that I made. Those are off the cuff the three that I can think of.
Yes. There are at least two types of discretion in law. Maybe there are three, but at least there are two. Maybe there are three. Do you want to share with the commissioners which ones they are and what the difference is between the two types of discretion?
Yeah, it's always difficult. It's a loose and the white and the strict discretion. When it's a loose discretion,
I'm sorry, please, I'm sorry to interrupt you. Just start afresh. There's something I may have missed when you started responding. Just start afresh.
Yeah, as I see it, it's a strict discretion or a loose or a wide discretion, and in the one case, the discretion of the court making the decision should not be set aside by the higher court if it was a strict discretion. If it is loose, then it would mean that the Court of Appeal can then decide that the one way or the other, the discretion was incorrectly executed or exercised and make an order.
Are there restrictions in regard to both as far as an appeal court is concerned, or is the position that in regard to the one type of discretion, there are restrictions, limited grounds upon which an appeal court may interfere, but in regard to there are no limited grounds, or there are still some limited grounds there too? I'm trying to understand whether your answer says exactly what I'm saying, but I'm not sure whether I can hear that in regard to one, seems to be, you are saying there are limited grounds for an appeal court to interfere.
Yeah.
In regard to the other one, I'm not sure that I understand what you are saying.
Yeah, I must say I must also now think about it.
Remember, you are nominated for the Supreme Court of Appeal now. You have to give guidance to the high courts and lower courts on matters of law. Yeah.
Now that is so, Chief Justice. I must say that I'm at this stage a bit confused, and I should not be. When the discretion is a strict discretion, then it is then the High Court will not interfere with the discretion unless it is clear that it was wrongly decided by the court. With a loose discretion, the court may decide, well, we would have exercised the discretion otherwise, and then make the order that it wants to make.
Thank you. Deputy President Betze.
Thank you, Chief Justice. Good morning, Judge Daffue.
Good morning, Deputy President.
Did I understand you correctly to say that you acted at the SCA for 2 long terms, with long terms and short terms?
No, I said for 2 terms. The one was in the second term of 2022. No, sorry. The third term of 2022 and the second term of 2023.
The third term would have been 2 months, August, September.
That's correct, yes.
And second term of May would have been 1 month, May.
Yeah,
Although your appointment was effective from the 1st of April.
that's correct.
NADEL has expressed some reservations concerning your candidature on 2 bases. One being, they say that you do not have sufficient appellate experience, and the question of your age. Insofar as the latter, you would have, if recommended for appointment, essentially 3 years at the Supreme Court of Appeal.
That is 3.5 years, yeah.
I didn't get the answer, Judge Daffue.
No, I say it would be 3.5 years.
Yes.
Do you want me to comment on Nadel's report?
Yes, please. Insofar as those 2 issues that they have raised.
Well, as I see, they've raised one issue, and that is and that's my age. Not that I didn't have sufficient experience. They specifically say the candidate has made significant contribution to the development of the law and is both qualified and experienced for consideration, as paragraph 2. And then in 4, they say we are, however, concerned about the candidate's age and that he will only have a few years at the apex court. What I can say in that regard is that, first of all, I thank them for the positive report that they've given. The issue of the age can be dealt with at the following level, and that is that I've got 3.5 years left. You will know that judges can perhaps get between 12 and 15 appeals per term. If you work even on an average of 50 per year, it would mean that I would be able to be involved in 175 appeals, which is a lot. And if you look at petitions, for example, at 2 per week, it would be over 350 petitions in that period. And if I then look at what happened in the recent past, Judges Dlodlo and, if I can just have a note, and Plaskett, both of them only served 3 years from 2019 to 2022 as permanent judges. And I must say both of them have made valuable contributions by way of their judgments. Then Judge Gorvin was appointed in 2021 at the age of 67, so he'll probably have 3 years also. Judge Wiener was appointed last year, and she will have probably 2 years. I'm satisfied that both of them also they've made contributions, valuable contributions, and I feel young, and I think I'm still energetic, and that I'll be able to make contributions, worthwhile contributions.
Thank you. And there's also the Black Lawyers Association also raising a concern about what they characterize as your lack of sufficient appellate experience, and of course, what they call your advanced age.
Yeah, Deputy President, I just want to know, are we going to refer to anything else in that report of theirs? because there are serious allegations made in the report that I would have believed that in terms of the guidelines, they should have dealt with it properly. I'm referring to clause 40. There's no sufficient substantiation for the allegations that they're making, which you haven't raised now. And I haven't given proper notice of these allegations. I'm referring you to paragraph 1.2, and I'm not going to read that because if that's not going to come up, then it's the end of the story. But those are serious allegations pertaining to my dignity, and I didn't have an opportunity to get full substantiation thereof. And I've got many friends in the BLA that deny that version. Are we going?
Well, I was only interested in
Yeah.
the query raised about your lack of sufficient appellate experience
Yeah.
and your advanced age.
Yeah, no, that's why I say if that is all that you're concerned about, my answer is the same as in respect of Nadel, is that although I only had the 2 terms in the SCA, I've had numerous experience, years of experience as sitting in appeals and reviews in the High Court, especially the last few years as the presider because of my seniority. But if one also looks at the JSC guidelines, the acting experience is important, but that should not be the overarching experience. And I still believe and maintain that I can make a proper contribution.
Thank you. When you were asked by the Chief Justice to explain to the Commission the difference between a wide and a narrow discretion, I must confess that the impression I gained was that you couldn't adequately articulate the difference from someone of your seniority.
Yeah, I must say it's perhaps because I'm a bit under stress here, and it's the two versions, either the narrow or the strict versus the wide, and the effect thereof. But I'm certain that if I can just go back to my notes, I'll be able. But so I probably, if I changed it around, then I changed it around. But I understand when a court of appeal can interfere and when it cannot interfere, on what basis it can interfere if it's the case.
And whilst you were being questioned by the Chief Justice, you asserted that you are diligent and industrious.
Yes, that's correct, Deputy President.
The concern which is shared among senior colleagues at the SCA is that when it comes to judgment writing, your judgments were not concise with linear reasoning in support of the ultimate outcome, and that you tend to delve too much on facts, citing well-known principles, needlessly quoting familiar precedent. What's your response to that?
Yeah, I must say, Deputy President, that I've looked at the email, the trails of this year. I haven't got last year's with me. I know, for example, in one case, it was said that I should shorten my judgment. I was also said that you should change paragraphs, 1 or 2 paragraphs to, but what I will say is and I say that without fear, is that my email correspondence will show, and I've looked at that the judges were satisfied with the reasoning, and if I may quote that, I can do that. I know there's confidentiality in conferences, but the point is that I was told, for example, well-written judgment. I was told that the judgment is in order, say, for example, change paragraph from this to that. And I'm also glad that in certain instances where I had to give notes to presiders, that they were satisfied with the notes that I've given. So it's possible that I perhaps put more into a judgment, but as far as I'm concerned, none of my judgments have been deleted and rewritten, so to speak.
And there was an instance where the decision was that the matter failed to be remitted to the High Court for it to deal with the merits. But your judgment went on to deal with the merits of the case, which in effect would have bound the hands of the High Court, so to speak.
Yeah, Deputy President, that is the matter where you were presiding. That was dealt last year. And all that I want to say is you are correct on the basis that I initially, because my view from the beginning was that the appeal should succeed, and my judgment became, the orders that I granted became eventually the majority's orders, although you and another colleague differed in the, not differed, but you wrote separate judgments. What I initially was, the intention was, is my view was, is that the appeal should succeed and the application should be dismissed. And on that basis, I dealt with the merits. But I was then convinced that, and remember, I was not the scribe initially, so there was a minority judgment. And then, whilst we were consulting, it was pointed out to me it should be better to not uphold the appeal and dismiss the application, but rather refer it back to the High Court to be dealt with by a different panel. And that was the ultimate decision. And as a result thereof, I took out a number of the arguments that one of the arguments that the points that I've raised in my judgment pertaining to the merits. That is, the judgment is with me here. The merits have not been, I've referred to many aspects pertaining to merits initially, which I took out because of the change pertaining to the order that we were in agreement as a majority.
You know, of course, that in terms of the practices of the SCA, before you circulate a judgment, you should satisfy yourself that if I was sitting alone in the High Court, this is the judgment that I would sign and then deliver.
That is so.
And there was an instance where I was constrained to send out an email to the members of the bench to say that I haven't got the luxury of time of reading one and the same judgment 10 times, and that those who wrote judgments must consider their judgments carefully and indicate to me when they are satisfied that these are their final judgments.
Deputy President, that is correct. I can tell you in the one case that I was involved, where the scope was somebody else, the argument was because we were uncertain after the conference as to the outcome, the scribe decided to send to circulate his draft on the basis that to get clarity from other colleagues before it was sent to the researchers. In one case, I did the same, where we were also, during the conference, there was uncertainty as to whether we will be able to agree with each other. And I send it out to the colleagues, saying that I'm sending it simultaneously to the law researchers, and when I get it back, I'll send it to them, which I've done.
In paragraph 16.1 of the questionnaire, this is what it asks of each candidate. List the cases where you have written a judgment, not more than 10, which you regard as being most significant, and why. You have listed those judgments, and they appear on pages, paginated pages 10 to 12. And looking at those judgments, in my view, they dealt with questions which are already settled. There was no new principle or a deviation from established principles or clarification of any judgment. You know, dealt with simple matters of statutory interpretation, interpretation of contracts, and so forth. What do you say to that?
Deputy President, are you referring to paragraph 18?
16.
Yeah, well, I've looked at 16.1. Which one are you referring to?
All of the judgments that you have listed there.
Well, the judgment, the first judgment is the one of the Minister of Higher Education, the 16.1. That judgment, the Minister got leave from me to go to the SEA. He decided to withdraw his application, and he arranged that the Act be changed. So, I mean, that was a serious, and that dealt with the jurisdictional requirements of Section 41A of the Higher Education Act that have not been met. So that was, and they substituted Section 42 from September 2017. So that was a very important judgment. The Oosthuis and Castro judgment was also important because that's about the exclusion clauses in insurance contracts. The two senior advocates that appeared before me couldn't give me precise arguments on the issue. The one got the previous night a judgment from, I think, New Zealand or Australia. And that judgment was important insofar as the SEA agreed with me, and then the importance came afterwards pertaining to COVID-19 and the insurers' allegations that they can rely on the exclusion clauses. So that's an important judgment as far as I'm concerned. And then the issue, well, there are others also. The ex parte, the National Director of Public Prosecutions, where they, the director attached the bank account of Baroda Bank, which with Nedbank, the whole bank account, which they couldn't do because they was looking for the money of one client of Baroda Bank. The other one of Sequoia was there were different views by the provinces in this country, and we were called upon to deal with the question of representation by a legal practitioner, whether the child was entitled to an automatic right of review. So, and we made and it was a full bench that was set aside there, put there. In Fredericton, the legality principle was applied. So, the Msimango case that went to the Constitutional Court, Ramabele, that case, there was never in the High Court ever a judgment pertaining to Section 342A, where you can close the defender, the accused cases. And I said this, justice is a one-way. It's not a one-way street. If it was fair to the state, it must be fair to the accused, and other way around. So, if you said I must go to paragraph, well, I don't know which other cases I must refer to, but those are the cases that are important.
Thank you. I'll conclude by asking you a direct question. Do I understand your response to be that those cases that you have listed under 16.1 introduce new principles of law or departed from established ones or dealt with new or developing areas of the law?
Well, not all of them, but surely the question in 16.1 is which you regard as being the most significant. That is the question. And I refer to that. But then in paragraph 18, the question there that's why I asked which paragraph are you referring to, because in paragraph 18, the question is, what would you regard as your most significant contribution to the law and the pursuit of justice? That's the question. And I dealt there with those cases, and the abuse of process in the MBD securitization case is very important. That's an old lady that signed a document in the Eastern Cape, and then they took judgment against her in the Free State by attorneys from Gauteng. And I referred that matter to the Law Society and to the Minister of Justice, because it was clearly that there was a serious issue there. And then my judgments pertaining to criminal cases, I am very adamant that we should do something about gender-based violence, and my judgments in criminal cases are clear that I've got a serious issue with that, and people that offend in my court in those regards, they must know that they will get serious penalties, sentences against them. And the Nakashle judgment is also only about the record keeping, because we've got problems in the high courts. All the high courts, we've got problems with the record keeping of matters that come to us on appeal or review. And I know that the Constitutional Court has written 3 judgments on that, but they didn't do anything to tell the department what to do to rectify the problem. And I believe that in that judgment I tried to indicate what should be done to ensure that convicted persons are not acquitted because of lost records.
Thank you, Judge Daffue. That's where I'll leave it. Thank you, Chief Justice.
Thank you, Deputy President.
Thank you. Before I go to the Minister, I will just mention for the benefit of those commissioners who might have been saying how, but we agreed 2 questions. What's happening now? We allow the head of the court, in respect of which we are interviewing a candidate, more leeway. So the 2 questions usually won't apply to the head of the court that is being, in respect of whom we are interviewing the candidate. So that's the reason why. Okay, Minister.
Thank you very much, CJ, and good afternoon, Judge.
Good afternoon, Honourable Minister.
Yes, I see, like myself, you are an ardent cyclist. I hope you also extended to privileged kids in the Free State.
Yeah, no, I'll try my best to do that. I must say that I haven't done it with cycling, but I've sponsored a soccer team of my gardener, kitting them out totally, but not with bicycles at this stage.
Okay. There is a judgment here on the ENGO and others versus the Premier of the Free State. In paragraph 1 of the judgment, you have made a remark about how you feel about writing this judgment. I'm not sure if you have it or you remember it, but
I remember
just to remind you a bit.
Yes, I remember it, Minister. That was the uneasiness that I had with first of all, the kids in the Free State, the social welfare of them, their housing, etc., against the province's ability to support and to provide financial means. That was for me a very serious issue because I knew at that stage that the province was under financial constraints. And I think that's what you referred to.
Yes. So what I'm struggling with upon reading the judgment, I could not understand, or I was struggling to understand why did you feel it necessary to put your personal feelings, how you feel about it.
Well, I had to, it's a balancing trick because I had to look at first of all, the obligations of the province in terms of Section 195 of the Constitution, and I had to look at the rights of the children to education, to housing, etc., in terms of the Constitution, Section 28, and all the other sections dealing with housing and education. So, in Afrikaans,
what I want to understand is, did your feelings on this matter influence the judgment?
No, not at all, because eventually I made an order that the province must pay because of I think it's Constitutional Court, the SCA judgments indicating that if you've made a promise as a department, you must comply in terms of the promise. So as a result thereof, and this matter was dragging on for many years, and I just mentioned, as a human being, that it was difficult for me to do this balancing trick. But I eventually did that in favor of the children.
Thank you, CJ.
Thank you, Minister. Mlambo JP.
Thank you very much, CJ. Good afternoon, Judge Daffue.
Good afternoon, JP.
You, correct me if I'm wrong, the only appellate court you've acted in is the Supreme Court of Appeal.
Please repeat.
The only appellate court you've acted in is the Supreme Court of Appeal.
That's correct, yeah.
Okay, not the LAC,
No.
not the CAC.
No.
Or not even the CC.
No.
Okay. Thank you, CJ.
Thank you. Commissioner Matolo Lepu.
Thank you, Chief Justice. Good morning, Judge Daffue.
Good morning, ma'am. Good morning.
Okay, I heard you saying that the BLA comments about your attitude towards attorneys is an attack on your dignity. Please correct me if I'm wrong. But I think for me, that's the issue that relates to transformation. If you had made a statement, and it's not only once or twice, the BLA members, they say that your attitude towards attorneys being judges is a concern to them. So, and you should have responded to them if you felt they were incorrectly quoting you. But from what I can see, and even from BLA members, you still maintain the same. Can you please clarify me?
Excuse me, can I just ask you to just clarify, do you say that I've made comments that attorneys cannot become judges?
Yes, Judge Daffue. If you look at paragraph 1.2 of the BLA's comment.
First of all, that's the issue that I raised with the Chief Justice, is that as I read the guidelines, that is such a serious issue that you should have given me sufficient substantiation. Tell me, where did I say that, at which occasion, and who were present there? Because I can promise you that from the time that I was still an advocate, a gentleman like Mr. Tekiso Musi became a judge in our court, and he became a judge president. And I regarded him as proper. He was 19 years an attorney before he was appointed to the bench. I had good relationships with him, and I had always, and the reason that I became a chair of the Free State Society of Advocates was because of the way that I tried my colleagues to understand that it is high time for attorneys to become judges. Mr. Justice Rampai was my colleague. Mr. Lakale was appointed together with me. I've learned so much from him as a gentleman, as a judge. Mr. Rampai the same. And furthermore, I was the one that dealt with the Future Leaders Symposium in Bloemfontein in 2011 because of my as chair. And what did I do? I asked Madam Justice Molamela at that stage, still 2 or 3 years at the bar, to give one of the keynotes, as one of my keynote speakers. She was an attorney that I knew well. Why would I ask her as an attorney, a previous attorney, to address bright advocates if I believed that attorneys were not properly or not suited to become judges? I can give you more examples. I can, for example, tell you what I've said when I was introduced as welcome to the bench, where I said we've got to make sure that we improve the skills of all our black colleagues so that the pool must be increased and that there's more time for more of them that can become judges. And what I've said there has been repeated over and over in the Judicial newsletter. I've quoted that. Well, I've got that. Madondo, AJP has referred there to. Our previous CJ has referred there to. The lack of chances of our black people to get their practices as attorneys off the ground. And we must improve their skills. And Justice Molamela gave a speech about the SA Sajay, and therein she also mentioned that training should be given. Sajay was there on the point of being implemented at that stage. And it's, I can go further. At my speech at the last meeting of the Attorneys Association in Bloemfontein in 2018, I gave a speech there, and the president of NADEL was there, the president of the BLA was there, and those people would know how I dealt with transformation and how I said that we must make sure that we must understand the LP, the Legal Practice Act is there to help us with transformation, and we must make sure that there's proper education for all. And I can't take it further. And what is strange to me, if I was so against attorneys, why would my colleague Mbele sent me a message of goodwill just now? Why would I be asked to act as acting deputy president for how many terms if I was against attorneys to be appointed as judges, whilst there are many attorneys on the bench?
Judge Daffue, you have responded to the question, but earlier on you seemed to complain that something went wrong with the procedure. I don't know whether you were saying you were not given these allegations prior to today, or whether your complaint is that it is not substantiated as far as you are concerned. What is the position?
Well, the position is that I've now allowed the question to be put in, and I've dealt with it. All that I say is procedurally it was incorrect to allow this to be placed on the record without sufficient substantiation. But I want to go further.
Hang on one second. Hang on one second. Are you saying that that document that has got that allegation was not given to you prior to today to enable you to comment on it?
No, no, Chief Justice. That document was given to me. The point that I raise about is that if you look at your own guidelines, it's not good enough to say this person is a racist or anti-transformation. You've got to substantiate, and that is the problem. There's no substantiation. They just said, it's sadly worrying, Daffue sadly has a worrying and deeply held view that notwithstanding the experience which they may have in the practice of law Attorneys will never, not black attorneys will never acquire enough skills to become judges. This view has not only been expressed to attorneys, but also to his colleagues in the Free State Bench, the majority of whom are black and former practicing attorneys. Now, all that I say is, I've got a letter of a colleague, an attorney who is on the Black Lawyers Association. He's a member of the BLA.
Yeah, but don't mix things, Judge Daffue. Somebody says you made a statement that attorneys either should never be judges or are not good enough to be judges. You get given that in advance. It gives you an opportunity to say, I never said that. Or if you want more information, you can ask for more information, isn't it?
Chief Justice, I beg to differ with great respect. Your guidelines say that if the reputation or dignity of a person is attacked, that allegation must be provided with sufficient substantiation. It's not the duty, it's not on me. I'm not the accused here.
Hang on, Judge Daffue. I'm putting questions to you. You're saying you are differing with me. I was just putting questions that when you are given a document, let's say, where somebody says you made this statement, if you remember or you know that you never made such a statement, isn't it the right thing to do is to deny that? Well, if you are not sure, you want more information so that maybe you might have made the statement, but in a different context, you might then say, well, I would need more information. So I'm asking whether that would not be the way one would be expected to deal with it.
Yeah, well, the manner that I try to answer is to show that I've never made such a statement, bearing in mind the history with our previous Judge President Musi, Judge Molamela, all my other colleagues, and the fact that I've been allowed to be practicing or acting as acting Judge President. Nobody has ever complained. There was no, so I deny fully and comprehensively that I've ever said that. All that the point that I'm raising is actually now beyond reproach because I've dealt with it.
Yeah.
And I can promise you, I sent this to a colleague of mine from Gauteng, and when he read this, he on his own sent me a letter. And I've got the letter, but I'm not going to give it to you because I don't want to put his name with it.
No, I think you have made your point, Judge Daffue.
Can I just say one thing also?
Yes.
Is that very recently, a colleague of us, or an attorney, passed away. I went to the funeral procession, or the what do you call it, where, and I was the only white person in any event there. There was a program. The program director asked me, the program had already people named as speakers. He asked me to make a short speech, which I did. The overall attitude.
Okay, Judge Daffue, I think we hear the point you've made. Commissioner Matolo-Lepu, were you done or not yet?
Thank you, Chief Justice. I think I'm done.
Thank you. Commissioner Dodovu.
Much better. Thank you, CJ. Good afternoon, Justice Daffue.
Good afternoon.
I only have one question, and this question has been traversed by the speakers before me. I want to really understand one thing from you. Firstly, there is no question that you have sufficient experience in the bench, that you've contributed in respect of your contribution in respect of jurisprudence. But there's only one concern, and for me it's a serious concern. You only apply now after serving more than 12 years as a judge. You served very, very little at the level of SCA and not any other appellate division. Now, my question would be, because you are left with 3 years or just over 3 years, what is it that is really, really exceptional, that is unique and special, that you can offer and contribute if you can be appointed, bearing in mind that you are going to only serve for over 3 years? Thanks.
Yes, all that I can say is hard work and diligence, and to be efficient as far as possible, and to make sure that the judgments that had to be written by me be written, and that I give proper contributions in the conferences, which I've done. Because of my knowledge of practice and procedure and things, and I can give two explanations to you. First of all, a judgment went out, which wasn't properly checked. When it was already delivered, I picked it up, I was on the panel, and I had to see to it that the judgment be rectified. The other one was where the panel wanted to make a provisional liquidation order on appeal. The appeal was upheld. And I said, but you can't just make that order. A provisional order must have a return date. And there are practice directives by the various courts. In Mr. Malambo's court, there are practice directives. You've got to comply with that. And as a result, I helped my senior colleagues with it. So I think I can make valuable contributions. Okay.
If I may just make a follow-up, CJ. You say you'll work hard and write well, and for me, that is not exceptional. It's not, I put it to you that it's not exceptional and unique. Every judge can do that. But I'm saying to you, you are left with 3.5 years before you retire, and you want to be elevated. And I want to consider that, but I don't see anything exceptional, and I want you to show me that I don't see that is exceptional and unique. That will place you ahead of other candidates and therefore propel me to consider your appointment.
Yeah. Commissioner, I can just say, look at my track record with great respect, and you can look at what the General Counsel of the Bar has said. They've in fact said it much better than I said it in my questionnaire. There's no issue about my commitment to the values of the Constitution, to the my knowledge of the law, and also the manner
Judge
in which
Daffue, I'm sorry. Surely you know what it means when somebody says they want something exceptional.
Yeah.
You can't tell them your commitment to the values of the Constitution, because there are so many of us who have that commitment.
You are right. The point that I want to make is my track record.
Sorry?
My track record is the point that I want to make. If you look at the timeliness delivery of judgments,
Yes.
the well-researched judgments, even if some of them have been set aside on appeal.
Okay, all right. Thank you. Commissioner Moimang. Commissioner Moimang is out.
Oh, thank you, Chief Justice. Good afternoon, Judge Daffue.
Good afternoon, Professor.
Just one question from my side. There's a judgment under 16.2, page 14, right at the top. Machabeng Local Municipality versus McDonald.
Yes.
Yes. The question that I want to pose is the opportunity that you had to develop the common law around an ownerless property, as you correctly pointed out that you declined.
Yeah.
Was the Maybe if you can just probably elaborate more on that. But the second part of that question is, given the fact that the Constitution makes provision for expropriation under Section 25(1) and 2, but also the Municipal Systems Act, Section 8(1), and the Municipal Structures Act, Section 83(1), gives the municipality the power to expropriate. Was the decline prompted by the fact that there are other avenues in case the municipality wanted to use this ownerless property for public good or in the public interest? Thank you.
It is so that I could have decided to say that there should be a total change from where the what we call bona vacantia, that ownerless property, normally in terms of years gone by and from the Roman times, were then regarded as the state or the property. My view was that with the evidence I had available to me and the arguments that were put to me, is it would be wrong to say that the third-tier entity like the municipalities will become owners, because you must remember that the standard principle is that the state becomes the owner, and the state is the national government. And I think that the Constitution makes clear the difference between the national, provincial, and the municipal and the municipalities. So there's a difference between them, and I just felt at that stage it would be incorrect to develop the common law. If I've made a mistake, they could have taken me on appeal, but that was my view. That we can't deal with it. That any property in municipalities can now become the ownership of the municipalities. The state is taking control of those properties, the national government.
Is your understanding of the state not inclusive of all the three spheres of government?
I'm not sure whether I follow. If I've made a mistake, the municipality could have taken me on appeal. I'm satisfied that it wasn't the right thing to develop the common law, and that's my final answer.
Thank you, Justice Daffue. Thank you, Chief Justice.
Thank you, Commissioner Nokesi.
Thank you, CJ. Good afternoon, Judge.
Good afternoon.
At the SCA, the courts sit as a panel. You are a panel of judges, either 3 or 5. And the judgment ultimately that is produces one. Is it beneficial for other judges who sit in a panel to comment in a judgment, make proposal for certain changes to be made, or is it something that demonstrates that the candidate or the scribe is not yet a fit person for that court? How do you regard? What are the benefits of the panel sitting of judges?
Yeah, well, I must say that I haven't been in one panel where the judgment, the first draft, was accepted as it is. The whole idea is that at the first conference, the scribe, everybody is giving his input, and then the scribe will provide the judgment. And thereafter it's circulated, and often there are extra comments from people, and then a final draft will eventually be finalized. Now, I, for example, can refer to one aspect where in a competition law issue where the scribe asked for comments, and within an hour I gave my comments, and that were included. So that's part of the judgment writing and conferences.
Last question. The presiding judge in a panel, is he one among equals, or a principal in that panel?
Well, I think he's one among equals, but most definitely I found that you get so much from the presiding judge, and they're actually working very hard. So they've got to give guidance, and they have got to check all the judgments of the scribes. So although they are equal, surely they've got a proper function to fulfill.
Thank you. Commissioner Marumwahai.
Thank you very much, CJ. Good afternoon, Judge.
Excuse me, you, Professor, I was wrong. Sorry, Professor, good afternoon.
No, thank you very much. I have two questions for you. One is more procedural, and the other one is more substantive. I'm not sure if when you were acting, you had a chance to do the special applications for special leaves to appeal. But nonetheless, I just want to give you a scenario, and I just want to see how you'll deal with this scenario. Assuming that there is a judgment from a judge sitting alone in the High Court, where the judge dismissed an application, and then an application for leave to appeal that judgment was brought, and the judge dismissed that application. And then the litigant who lost decided to appeal not to the full court, but to the SCA. First, I want to understand, is that judgment appealable? Depending on your answer, how should those two judges who are dealing with special leave to appeal have to deal with that kind of judgment? No. I'm not sure if you understood the scenario.
What judgment is appealable?
Remember I said there was a judgment which was dismissed. Then the litigant applied for leave to appeal against that judgment. Yeah. Then the judge dismissed the application for leave to appeal. Well, then the litigant went to the Supreme Court of Appeal, not to the full court.
No, you go to you go on a petition to the Supreme Court of Appeal. You don't go to you go on petition to the Supreme Court of Appeal. The unsuccessful litigant.
So is your answer that that judgment is appealable?
Well, I don't know what the facts is, but if we accept that the judgment is appealable, the moment that judge in the High Court dismisses the application for leave to appeal, you as litigant is entitled to go on a petition to the SCA.
Okay, let's assume that it is. How then do you deal with it as the two judges who are considered in that judgment?
Well, we do it in chambers. Each of us get the papers, and we consider it. And the junior judge normally goes to the senior judge and says, "Well, I've read the papers. Are you ready? Can we discuss it?" And they make up their minds as to whether they should grant leave to appeal or not.
And where would the appeal be heard? By the Supreme Court of Appeal, or will it be taken back to the High Court?
They can decide. Either if it's a serious, especially a legal issue, then the SCA will do it. Otherwise, they'll send it back to the full bench.
Okay. No, thank you very much. My second question is in relation to a judgment that appears on page 10 of your questionnaire. Buota versus Buota.
I think it's on page.
I think it's easier if you go to page 10.
Well, I'm not sure whether the pages are correctly numbered, but I know the judgment is on my page 5 of my questionnaire. That is the friendly sequestration issue.
Yes. Yeah. Yes. In paragraph 12 of that judgment, you stated something that is quite correct. That the applications for sequestration, the court has a discretion to allow it, and even if the requirements for sequestration are met, the court can still reject the application. I've always wondered what would be the circumstances that would lead to the court, even though the requirements are met, to actually not grant the application.
Well, for example, even if it's a friendly sequestration, because it is clear that father that has lent money to his son, claiming 1,000 rand, they come and they can show that they've complied with that requirements, but it is clear that the only reason for that is for the debtor to get released from his creditors. It's clear that they try to prevent the process to be followed. What would happen in such a case is you dismiss the application, the creditors would be entitled to issue summons and to get warrants of execution.
Thank you very much, TJ.
Thank you. Commissioner Nyambi.
Thank you, CJ. Good afternoon, Judge.
Good afternoon.
The last time you were here was April 2021,
That's correct. Yeah.
even though it was a DJP position in Free State. Between then and now, something that is, because now it's the issue of SCA, and you are left with the 3.5 years, as has been explained. Between then, when we were available to be the DJP in Free State, and now, any particular outstanding thing that has happened that we have to seriously consider this time around compared to then when you appeared in the GSC?
Anything that happened?
Anything that is outstanding that was not considered then, that now we have to seriously consider so that we can...
Oh, I see. Well, I think it's a difference in the approach, because there was the issue of leadership in that division, where I've acted many times. And may I just say, is that in that leadership position, on a weekly basis when you are there, you have to look at all the files that are given to you for the next week. You've got to check each and every file to see how complicated the matters are and to whom to be issued. So I acted only as acting DJP since then, this last term for a while, a part of the last term. But nothing different happened except that I had the 2 stints at the SCA. There's nothing else that happened. A few adjustments have been reported, but the position is the same. There was a leadership role. Here is a bit a different role because, it's not the leadership capacities that are so much so required at this stage, but whether you can fulfill the job as a Supreme Court of Appeal judge.
My last question, what is your summation of the state of transformation in the judiciary?
I think it's very good at this stage. If you look at the SCA, 55% of the judges, 54.5% of the judges are already female judges, and 45.5% are male judges. And I think it's over I've got the figures. The percentage of white versus black is also, I think there are 13% white males, 9% white females, that's 22%, and I think 77% are not white. So if you look at that, we've moved a long way from 1990 up until now. If you look at all the female justices that have been appointed at the various divisions, the Constitutional Court, the SCA, and also at the various local divisions, I think many strides have been made. And what I can say is if I'm appointed, for example, as a white male, it's not going to be a reverse gear of the transformation. It's not going to change because there are 3-4 vacancies. So I'm not going to be a stumbling block for transformation. In fact, it will show the diversity. Justice Matlanga has recently also written an article indicating that the diversity must be properly considered on appeal benches, and he referred to Sidney Kentridge and some other people as well in that regard.
Thank you, CJ.
Thank you. Commissioner Singh.
Thank you very much, Chief Justice. Good afternoon, Judge Daffue. I'd just like to know, in your career as a judge so far, at different levels, have you had occasion to pen any minority judgments?
Have you ever?
Occasion to pen any minority judgments?
Yeah, I have. I think in 2 instances.
And what is your general view on minority judgments?
Well, if you're wrong, you're wrong. I accept the majority's decision, and all of us, like in the SCA, in the Constitutional Court, we often disagree, and I accept the majority decision.
So you've only had 2 minority judgments that you wrote?
I definitely, I can only remember the 2, and that was quite recently also.
In the SCA?
No,
While you were acting?
No, the minority judgments were in the High Court. In the High Court, not the SCA. The SCA, my judgment became part of the majority, if I may say so.
Thank you, Chief Justice.
Thank you, Commissioner Singh. I've noticed your hand, Commissioner Barnard, Commissioner Baloyi.
Thank you, CJ. Good afternoon, Judge. I want to go back to the concern about the time that you still have to serve on the bench, the 3.5 years odd. And it's a matter that I would like to get your comment about from a different perspective. You, in these 3.5 years, if you remained in your division, you will continue to be one of the senior judges, as I understand. I'm assuming that the division doesn't have many senior judges. So you would continue to be a senior judge. You would continue to provide leadership, support, and guidance to the more junior members of that bench. That is, if you remained where you are. And yet, if you went to the SCA, if you were to be appointed by the president to the SCA, in that 3.5 years, you will be a junior member for most of it.
Yeah, that's
now, let me finish.
Sorry.
Now, my concern comes from this, that aren't you going to contribute even better and more by retaining your senior position presently, where you sit, according to your judgments, most of the time you sit alone, and you're providing light on these important cases that you have referred us to, vis-a-vis going to the SCA, where you're going to necessarily be part of a bench and be a junior in that. Isn't the judiciary and the development of our law going to be better served by you completing that 3.5 years where you are today?
Madam Commissioner, the problem with such a question is that most of the judges that seek to go to the SCA are senior judges in their division. Whether you come from Kimberley, Bloemfontein, or Grahamstown, you are a senior judge. So what goes for me goes for all the others in the smaller divisions. But I agree with you that I can still give leadership I would be able to give leadership in the High Court. But on the other hand, I'm satisfied that I can also make valuable contributions in the SCA, which I've done. And the kind of work in the SCA is of such a different caliber as you would normally get in the High Court, where you sit in criminal trials, for example, or normal motion court matters, which are not. Which can be done by junior people with great respect. So yes, you are right to a certain extent, but the issue will be the same for other people as well.
Can I just lastly say, I don't find the comparisons or references to other judges in the way that you're doing now to be helpful, because we are not discussing the circumstances of each appointment. I'm speaking specifically to you, being senior but with 3.5 years to go.
No, I understand that.
And coming from a particular division.
Yeah. No, I understand that, but you will also remember that in the last, there are many of my colleagues where I've got 12 years now. At least the JP has got more than me, and there's another judge that's got more time than myself. And some of the other judges are there for 10 years, for 8 years. So they're not junior judges of 1 or 2 years standing. So they are capable people that on their own can be regarded as senior judges at this stage. And I'm satisfied that that will not make so much of a huge difference. Although I've assisted for especially acting judges tremendously when they acted there, my other colleagues can do the same.
Thank you, CJ.
Thank you, Commissioner Baloyi. Commissioner Barnett.
Thank you, CJ. Good afternoon, Judge Daffue.
Good afternoon.
My question is about the principles involved in cost orders. So how should cost orders be dealt with on appeal? Does this differ when the litigation involves constitutional rights litigation? And then finally, how should a court of appeal deal with an appeal against a cost order? So cost-related things.
Yeah. Well, the BioWatch principle by the Constitutional Court is available in constitutional matters. Even if you're unsuccessful, the court is not going to give a judgment against you. And obviously, the court is not always, the appeal court is not always willing to deal with cost issues only, but and not dealing with the merits. But I could gather that it is possible where it is a clear case where the litigant has lost a constitutional issue, matter on a constitutional issue, and costs are were granted against that person, that he might have a good chance to take that on appeal only, and that the Court of Appeal can deal with a cost order based on the BioWatch principle.
So when would the court interfere with the costs principle?
Well, I suggest that the court can interfere.
I think the question is when will the court interfere with a cost order? And I think he's talking an appeal court. He confirms that that's the question he wants you to answer.
The question is a judgment from the High Court going to the SCA.
The question is, when will an appeal court interfere with a cost order made by a lower court?
Yeah, well, that's what I said, is that the court will seldom just interfere with a cost order if that is the only thing on appeal. Because it's very seldom that the Court of Appeal will deal with the cost only, but in a case where the constitutional issue was raised, the litigant lost his case but got a cost order against them, then surely the Court of Appeal would be entitled to say, well, we've got to follow BioWatch, and in terms thereof, the Court quo incorrectly made an order pertaining to costs, and that should be substituted with a proper order.
Sorry, Chief, if I can maybe, can we just leave the constitutional aspect out of it now? That just a normal court of appeal and a cost order from a lower court. When would the court interfere with such a cost order? What are the conditions?
Mr. Barnett, I must say that as far as I'm concerned, is that cost orders shall seldom be interfered with, because you've got to go to the merits, and if the merits are not on appeal, my view is that there would seldom be scope for a Court of Appeal to deal with cost orders granted by the lower court, if that is the only issue on appeal.
I don't want to belabor the point, it's my last thing, but what is important for me is you keep saying it won't really happen, or it won't often happen, or it will seldom happen. But the question is, when can it happen? When should a court interfere with such a cost?
Well, clearly, if the Court quo has misdirected itself and on issues, or exercised its discretion totally incorrectly, then the Court of Appeal would be entitled to do that.
Thank you, Judge. Thank you, Chief Justice.
Okay. Thank you very much. We've come to the end of the interview. Thank you very much, Judge Daffue, for making yourself available for this interview. You are now excused.
Thank you very much, Chief Justice. I appreciate the opportunity to be here.
Thank you.